Good evening, everyone, and great to see you again. Today we've got a very special guest appearing with us. So for those of you who have been following what we're talking about on Facebook, the government is bringing in an amendment to the Constitution next week in Parliament in the upper house. And so we're very lucky to get in contact with Professor Greg Taylor, who I've got with us here tonight. And Professor Taylor is a fellow of the Royal Historical Society. He's an honorary professor for common law and comparative law in Germany. He's a barrister and solicitor for the Supreme Court of Australia. He works at he's a professor at the Adelaide Law School, and is also worked at RMIT. So, and one of the very interesting things about Professor Taylor is he literally wrote the book on the Victorian Constitution back in 2006, I think. Is that right, Mr. Taylor?
Yes, that's right.
Yeah, so please welcome Professor Greg Taylor. So let's start with a little bit of history about the Constitution of Victoria before we start talking about the legislation that the government wants to bring in. Could you tell us maybe a little bit about, what's the history of the Constitution of Victoria and what's its purpose and what functions does it serve?
Yeah, certainly. And thank you for the invitation. It's always a pleasure to talk about my favourite topic. The Constitution for Victoria dates originally from 1855. As you probably know or may know, Victoria split off from New South Wales on the 1st of July, 1851. And the Colonial Office was very keen for all of the Australian colonies to have a democratic constitution. That comes from the experience of the Colonial Office with the American colonies. They had worked out that it was a very bad idea to pick arguments with the colonies and deny them self-government. Because you would probably lose even if you won the battle, you'd probably lose the war, which of course is exactly what they did in North America. So they were only too keen to avoid that mistake in relation to what historians call the Second British Empire. So pretty much as soon as Victoria was created, the Colonial Office started suggesting we should have a proper democratic constitution. The way it worked was that Victoria elected a single chamber legislature, or the men of Victoria anyway, with a certain income, and that drafted a constitution on behalf of the people, which was then sent to London for enactment. London wasn't keen on a couple of things they proposed, so cut them out, but it enacted pretty much the rest. So you'll notice that the Victorian Constitution was never voted for by anybody specifically. It was drafted by a legislature that people had voted for, but once it had been written, nobody got the chance to vote in a referendum yes or no, which would have been very peculiar and advanced for that age. And that's one of the reasons why our Victorian state constitution can still be amended nowadays without a referendum.
Well, that's the question that many people have been asking me, because when I brought up the idea of, or told people about the idea that we were amending the Constitution in Victoria, many people said, "Why don't we need a referendum to do that?" And I think you've just answered the question there. So, yeah,
Sorry, go on.
Sorry, go ahead.
Oh yes, well that's one of the answers. There are essentially three reasons why we don't need a referendum to amend the Victorian Constitution. One's the one I've just given. It was never approved by the people in the first place. Secondly, unlike the federal constitution, it doesn't divvy up powers between two levels of government. So you can have just one level of government responsible for amending it, right? Obviously, if we had the federal parliament responsible for amending the federal constitution, they'd give themselves all power, right? That is not a problem with the Victorian Constitution because it doesn't divide power between two levels of government. And thirdly, it's not the British tradition, which of course in 1855 was still very important. It's not the British tradition to have referenda, or it wasn't then.
And then my understanding is that the next major reform was in 1975. Is that correct? What happened then?
Yes. Well, there were various changes and so on in the, how many years is it? 120 years between 1855 and 1875, electoral voting laws were amended, all sorts of things happened. But yes, in 1975, the document from 1855 was formally repealed and declared no longer to be legislation, and the piece of legislation we now have, the Constitution Act 1975, was enacted as an update. It wasn't much of an update. It was more or less just a tidying up exercise, and above all, rather unnecessarily, I think, the government of the day, the state government of the day, was worried that if you kept the 1855 Constitution, which was still formally, in formal terms, a statute of the British Parliament, Gough Whitlam might somehow be able to change it or get the Brits to change it. So to head off this non-existent, he had other problems, of course, in 1975, head off this non-existent problem, they said, okay, we will officially repeal the legislation from 1855 and bring in a 1975 version. And that was pretty much just a tidy up. The real change, of course, happened in 2003.
Yeah, so what happened in 2003 then?
Well, how long have I got? But yes, I'll be as brief as I can. Yes, in 2003, perhaps two important things happened for the purposes of the present talk. First of all, the Legislative Council was reformed. The Legislative Council, of course, is what David is a member of. It is the upper house of state parliament. It's what the Americans would call a state senate, but we don't have that terminology in this country. But yes, the upper house of parliament, and that was reformed so that the method of election was much more a Senate style, federal Australian Senate style method of election. I won't go into the details here, but that was a necessary reform. Up to 2003, the Labor Party had never had a majority in the upper house, which clearly indicates something was wrong. Not that I'm obviously here to complain about things on behalf of the Labor Party, but if over 150 years, one of the two major political parties has never had a majority, then clearly there's a bit of bias there, and there was. So that was removed, and a more modern Senate-style system was brought in. And secondly, in 2003, there was a big package of what constitutional lawyers call entrenchment. And entrenchment is when you make the Constitution harder to amend than it usually is. And that's obviously pointing towards our current debate.
Yes, so that does lead us towards our current debate. So back before the 2018 election, the Labor Party promised to ban fracking. And so for those of you that aren't aware, fracking is a technology to extract oil and gas and other things out of the ground. Now, they promised to not only ban it, but put that ban in the Constitution. Now, it's already, fracking is already banned. Like, you can't frack at the moment, but they wanted to put it in the Constitution. Now, for anyone that knows anything about constitutions, and Greg knows more than anyone that I know, that seemed, when I saw that, when this bill came before me, that seemed a bit weird to me to put that in the Constitution. What are your thoughts on that?
Yes, it is very strange. We have not had that type of constitution traditionally in Australia. I think it might in part be an import from our beloved cousins across the Pacific, where they have the idea there in the United States of America that the Constitution is something that should make us all stand up and cheer and tell us the nature of our society and all this sort of portentous stuff. That hasn't really been our constitutional tradition in Australia, which has been much more modest and concentrates really on machinery and giving the democratically elected members of Parliament guidance, but in the end, a fairly wide level of discretion about what type of legislation they enact. There's only one comparable provision that I'm aware of, which is also in Victoria, which says that water distribution authorities must not be privatised without I think from memory, a 3/5 majority in both houses of Parliament. No other state has anything even remotely like that, because it's just not been the tradition in Australia to put policy preferences in constitutional documents.
And why would a government want to put something in the constitution like this? It's already banned, right? So we already have, and we have other technology prohibitions in Victoria. So we have the Nuclear Activities Prohibition Act 1983, which bans nuclear technologies. So why would a government want to put this type of technology prohibition into the constitution, do you think?
Yes, that's a very good question. And the obvious answer is because they care deeply about it. But of course, they care deeply about a whole lot of things, as indeed they should do. We don't want a do-nothing government. But yes, where is this going to end? If we put everything in the Constitution that we care deeply about, we're going to end up with a 1,000-page Constitution, and with Parliament constantly having to look up to see what its powers are, and whether somebody 30 years ago decided, I don't know, that, I can't think of anything, but whether somebody decided 30 years ago that some technology that's now considered to be perfectly okay was a real danger. So yes, I can't see any reason for singling out fracking as distinct from anything else for this treatment.
Yeah, and this is sort of my concern as well. Technologies change over time. Often when they start out, they have problems and then they get better over time. And it just seems to me to be very short-sighted to effectively entrench something like this, because it would require a larger, a supermajority to vote to get rid of it as well. Is that correct?
Yes, if it's valid. And I can try to describe, if you like, in 5 minutes or less, whether or not this is effective. So yes, there are restrictions on when Parliament can do an entrenchment. Remember, an entrenchment is when you make it harder to legislate than it otherwise would be. You add something in, like a referendum or a 3/5 majority or something, making it harder to legislate. It's completely different if you make it easier to legislate. So if you say the upper house can't block the budget, which the Victorian Constitution does say, that's not an entrenchment because it makes legislating easier. In this case, we're talking about making legislating harder. And so that's known as an entrenchment. And the law puts limits on when you can do one of these entrenchments. At least the majority opinion of scholars and the case law that we have, which is not much, suggests that you can only stop Parliament from legislating in the normal way if the two conditions set out in Section 6 of the Australia Act are both satisfied, and those conditions are, first of all, the hurdle for legislating has to be a manner and form. That's the phrase used in the legislation. It has to count as a manner and form under the legislation. And secondly, the topic of the legislation has to be the Constitution, powers or procedures of Parliament. And this is a rule that goes back to 1865. The fracking legislation it's certainly not about the Constitution, powers and procedures of Parliament. It's got nothing to do with how Parliament is set up. And it's only doubtfully a manner and form. 3/5 majority may or may not be a manner and form. The courts have not finally spoken about that, and there is no consensus among scholars. So if we take the majority view of scholars and the view in such case law as we have, Parliament is being asked to do something which it actually cannot do, which is to tie its own hands for the future. Now, there is a minority view, and the minority view essentially says that Parliament can do this at any time. The case law points away from that. It is not a popular view among scholars, but presumably it's the view that the government is taking as part of this legislative attempt. Assuming it's wrong, assuming the majority view is right, then you can put something in the Constitution that says, you can't legislate on this topic unless 3/5 of the Parliament agree, or, let's go to town. 7/8 of the Parliament agree. All members of Parliament agree. And you get the endorsement of the Labor Party Central Executive. And I don't know, Anthony Albanese and Scott Morrison both agree. Now, where's this going to finish? You can put something in the legislation that says Parliament can't legislate unless conditions A to Z are satisfied, but that is ineffective. Parliament can simply ignore it if the majority view is correct.
Yeah, so it's an interesting thing. So what we're seeing here is two things or two big problems, and please correct me if I'm getting this wrong. One is we're putting a technology prohibition into the Constitution, which is a sort of strange and maybe inappropriate thing to put in the Constitution. But secondly, it's not even certain if this would have any real effect if it was actually challenged in a court. As you acknowledge, there's differing views on that, but it doesn't seem certain that it would even be effective. So it's more for show. Does that sound right?
Yes, in fact, I would go so far as to say it is almost certainly not effective.
Right.
There's not a great deal of doubt among the scholars and in the case law. But yes, I think that puts it quite well. There are always two questions here. First of all, is it a good idea? And secondly, can we do it? So, for example, the Victorian Constitution says you can't have more members of Parliament without a referendum.
Okay.
In my view, that is a very bad idea because obviously it means in 100 years' time when the population's tripled or something, we'll still have the same members of Parliament because nobody's ever going to vote for more members of Parliament. So in my view, that is foolish, but it is effective because it is about the Constitution of Parliament and it sets out a manner and form, a referendum. That, under the case law, is a manner and form. So foolish, but effective. Whereas this one is foolish and ineffective.
Okay. Well, my colleague Tim Quilty and I from the Liberal Democrats will be opposing it next week. I don't know other people's opinions in Parliament on this yet, but we're hoping that more people will oppose it. So I think it's also important here to separate the two different issues. One is whether people want fracking or not, and whether that's a good idea or not. And secondly, whether this is a good way to get rid of fracking for a very long time. And we're not even sort of arguing about fracking from our point of view. We're more concerned with what's happening in the Constitution here. So that's my main concern. But everyone else is talking about fracking, of course.
Yes, and it's easy, of course, to overlook or to not to consider the constitutional refinements, and of course, in some ways, it's just a sideshow. I mean, the Constitution is there to enable legislation, or should be there to enable legislation, to enable the democratic will of the people to prevail. Whereas essentially, what this bill does is declare one side of the debate to be the winner forever.
Which seems very democratic to me.
Yes. If in 5 years' time a government's elected, or whenever the next election is, the government's elected next year or in 5 years' time, which says we think fracking is a great idea, let's go for it, and technology has changed, well, then that's the democratic will of the people. And, why should the Andrews government, for all its undoubted achievements, why should the Andrews government govern us from the political grave?
That's an excellent way of putting it, governing from the political grave. I haven't thought of it that way, but it's exactly what's going on. So we've got a couple of questions come here, and there's a couple of really good questions, and apologies to everyone in advance. We're not going to be able to get to everyone's questions, so I'm just going to pick and choose a few. But Jason's asked here, is there any truth that the Victorian government in 1975 changed the Victorian Constitution and they needed a referendum to do so? Wasn't it bound by the letters patent, meaning it would need the Queen's authority to change it? Now, I don't know the answer to that, but I'm sure Greg might have an idea about it.
Yes, no, there was no reason to do that. As I mentioned, the 1855 Constitution was enacted by the Imperial Parliament. What actually happened was the Legislative Council of Victoria, the single chamber legislature, came up with this constitution, the draft constitution, and sent it to London for agreement, as the British legislation required. The Colonial Office was not happy with bits of it, only a couple of small bits, and so they changed it and then simply put it through the Westminster Parliament as an act of the UK Parliament. But when they did that, they were alive to the need for it to be capable of amendment in Victoria. They don't want to be bothered in Britain. Every time we increase the number of members of Parliament from 25 to 26 or something, they don't want that sort of nonsense every time we do that. So they put in a clause that said the Victorian Parliament can amend this constitution, even though it's an imperial enactment. We give our power to the Victorian Parliament to amend this constitution any time they like. So that was the rule. Under, first of all, the instructions to the governors, and then the Australian States Constitution Act 1907, if my memory serves me correctly, there was a rule that amendments to constitutions did have to be sent to London for the Queen's personal assent. And that was an opportunity for the Colonial Office to, just check you weren't going to, outlaw Christianity or, to declare, the Queen deposed or something. They had that little final check in there that any constitutional amendments had to be approved by the Queen personally, not by the state governor, as is normal with legislation, but by the Queen personally. But of course, in 1975 they did that. They were aware of that requirement, and so they sent the legislation off to London for the Queen's personal assent, which was then granted. So, yes, I suppose in a way there was a requirement, such as was mentioned in the question, but it was fulfilled.
Right, so that's really interesting. I actually didn't know a lot of that, history. And another interesting fact: the Legislative Council, the actual physical chamber where we sit, because it was built before the Federation, it still has the British coat of arms in there, so which is quite interesting. But so now we have it so that the governor can give assent to legislation in Victoria. So this is another thing that people have been asking me about. I think maybe there's a bit of a confusion about the role of the governor and the governor general. People might not quite understand the difference between those. Could you maybe give a bit of insight into what the role of the governor of Victoria is, as distinct from the governor general?
Yes, the governor of Victoria is more or less the counterpart to the governor general, except at state level. So at a federal level, the governor general opens Parliament and gives formal royal assent to legislation, and also has a variety of ceremonial duties and speech-making duties and all that sort of stuff. And on the rare occasions where the reserved powers are needed, the Governor-General exercises them on behalf of the monarchy. And every Australian state also has its own copy of that role, although historically, of course, it was the other way around. Historically, the state governors came first as colonial governors, and the Governor-General came along later, obviously, in 1901. So, yes, the governor is now empowered. The Victorian governor, the head of state for practical purposes of the polity of Victoria, is now empowered to give assent to all legislation in Victoria. I referred a couple of, or perhaps 10 minutes ago, to the rule about when you can have an entrenchment, which is in the Australia Act 1986. The Australia Act 1986 was a general tidy up of various odds and sods and colonial rules that were no longer relevant. One of those was this rule I just mentioned, which said that any alteration to the Constitution had to be sent to London for the Queen's personal assent. That rule was also zapped by the Australia Act 1986, which was legislation both of the British and federal Australian parliaments, and is definitely valid. So there is now no requirement for the Queen personally to endorse any Victorian state legislation.
Because she gave the endorsement for that act itself. Is that right?
That's right, yes. That act was enacted by both the British Parliament, in case we couldn't do it validly here, as their farewell appearance as the Imperial Parliament, and also by the Federal Australian Parliament under a particular provision of the Federal Constitution. And of course, both pieces of legislation were signed by the Queen. The Queen, in fact, came specially to Australia to sign the Australia Act here in Australia. I'm old enough just to remember this. Bob Hawke was the Prime Minister, and there was a bit of a media event at the time, and she signed it, Elizabeth R., and thus it has the Queen's endorsement. Wow,
I didn't know that either. So there's another question here about the Governor of Victoria and how they have the ability to remove the government. Under what conditions might that happen? Like, is that correct, firstly? And under what conditions could that actually happen?
Yeah, well, of course, it's as a matter of strict theory, the governor could, of course, dismiss the government at any time, but that's strict theory only. We have these informal rules of constitutional law called the Constitutional Conventions, and the Constitutional Convention says that the Crown, in this case the Victorian State Governor, must appoint as Premier, head of the government, whoever has a majority in the lower house of Parliament. Now, of course, at federal level, as probably everybody listening will know, that went a bit wrong in 1975.
Yes.
The conditions under which that went wrong do not exist in Victoria because, as I mentioned a while ago, the upper house in Victoria can no longer block the budget. The other difficulty with the Crown simply dismissing the head of government at a whim would be that you would then have no government, obviously, and so you have to have an election to elect a new government, but Victoria has fixed terms. So you can't just have an election as Sir John Kerr had in 1975. You can't just have an election because the Crown feels like one. It's not legal. You can only have an election on the fixed term date unless either you have a no confidence vote in the lower house that's passed and no other alternative government is formed, or alternatively, the government in power asks for an early election because they've got an important piece of legislation that's being blocked by David and his fellow upper house members. So yes, in theory, the Crown could dismiss the state premier because he can't pronounce the word kilometre correctly, as Professor Geoffrey Sawyer once suggested laughingly. But in practice, the Crown could not dismiss the Premier except in the most extreme circumstances. So, for example, if the Premier lost the election and refused to resign, then it would be legitimate for the Crown to dismiss the Premier.
That clarifies it. So all the people out there that were hoping that the governor might get rid of the government because you don't like the government, it doesn't look like that's a likely thing to happen. So that's a bit of bad news for those people that were hoping that, I suppose. I've got an interesting question here. I'm not sure what the meaning of it is. They're asking, who is the Queen of Australia?
Oh, well, of course, we know the personal identity of the holder of that office. There are all sorts of more or less interesting, he said archly, academic debates about whether the Queen of Australia is actually 8 queens, one for each state, or 7 queens, one for each state and plus a federal one, and all sorts of other quasi-theological questions like that, which personally I think are a waste of everybody's time. But yes, the Queen, it keeps some scholars allegedly gainfully employed, but I can't get excited about it. But yes, of course, the Queen of Australia is, well, I suppose I can say, the question actually might be asking is, the Queen of Australia is an office. And of course, we know that the Queen of Australia is also the Queen of, I think, 15 other countries. But that doesn't make Australia and the United Kingdom one country. Nor are, of course, Australia and Canada or Australia and New Zealand, just as if you are president of the Glen Waverley Bowling Club and also president of the Glen Waverley Bridge Club, that doesn't mean that the Glen Waverley Bowling Club and the Bridge Club are the same organisation. You have got 2 offices that just happen to be held by the same person. So that might be what the question is getting at. And in fact, there have been all sorts of arrangements like this. It's known as personal union among the monarchies of Europe. So for a while, Sweden and Norway had the same king, and Hanover and Great Britain had the same king, and there are various other circumstances in history in which 2 separate monarchical offices of 2 separate countries have been held coincidentally by the one person. So that's who our Queen of Australia is.
Okay, so all right. Just looking. Okay, so there's a question here. Are these kinds of constitutional changes something which has occurred in other states, and has it happened very often? Is this an unusual thing, what we're doing here, I think is what they're getting at?
Yes, it's very unusual. Constitutions have not generally had policy preferences in them. However much fracking may be a bad thing, on which I actually have no opinion, it is not the sort of thing you'd expect in any Australian state constitution, and none of them has anything remotely comparable to it, because in our Australian constitutional tradition, constitutions have been seen as enabling. They have enabled the people's will to be expressed, not tried to restrict the expression of the people's will, which is where this would be going. I mean, if in 5 years' time the government's elected, as I said, which is mad keen for fracking, then they would be governed from the grave by the Andrews government. So it's quite foreign to our tradition to have these policy preferences put in legislation representing the views of one era or one government that may not necessarily appeal to later eras or later governments.
Can you think of any examples like this in other states, or are we sort of leading in a way, leading to governing from the grave?
Yes, I think we probably are. I can't think of any other examples in all other state constitutions that I can currently think of. And I must confess I haven't checked that this morning, but nevertheless I've been dealing with this now for 25 years. In my experience, in the other state constitutions, you will generally have only machinery entrenchment. So, for example, in New South Wales and South Australia, you cannot abolish the upper house without a referendum. In Queensland, you cannot bring back the upper house without a referendum. But all of these types of entrenchments are machinery entrenchments like that, capital C constitutional entrenchments, not something that's really foreign to constitutional law.
Interesting. Well, that certainly helps solidify my understanding of what's going on and makes me more determined to fight what the government's doing, I think. But that was very educational to me, and I hope other people that were watching here, about the history of the Victorian Constitution. I didn't know that the Queen came out herself to sign the Australia Act either. I never knew about that. That's quite amazing.
I think that's the last time that the Queen personally gave royal assent to legislation of Australia, obviously, not the UK, but the last time she did that. She also, on the same visit, she also signed instruments which abolished the distinction of knighthood and the Order of Australia, which, as we know, became controversial 25 years after that. So, yeah, she did a couple of things when she was out here in 1986.
And another interesting bit of information in the Legislative Council, so that's the upper house, that's my house. The Queen is allowed to enter that place, or one of her representatives, which is the governor, and there's a special chair in there that sits all the time, and the only person that's allowed to sit in that chair is the governor or the Queen herself. And above that, it actually has the British coat of arms, the unicorn and the lion. So, which is quite it's quite a beautiful chamber, actually. If you haven't seen it, Greg, come along and I'll show you around sometime, because it's very, very beautiful piece of architecture.
Yes, thank you. I went there some time ago. Sorry about that. Yes, so this tradition actually goes back to the time just before the English Civil War, 1642, when Charles I burst into the House of Commons and arrested 5 MPs. And ever since then, the tradition has been that the Crown's representatives does not go into the lower house. Yep,
I didn't actually know a lot of these traditions until I got elected, and it's quite fascinating. And we also have a rod called the black rod, and it looks like a weapon, and that's because it is actually a weapon. It's meant to. I think it's meant to protect the people from angry MPs or something. Yeah.
Yes, I think that's right. That's also why, of course, you have your state opening of Parliament in the upper house, because the Crown's representative by tradition is not allowed in the lower house.
Yes, and I got to experience that. I had the privilege of experiencing that myself, where all the members crowd into the upper house. It's not really designed to fit that many people, but we squish in there. And it's a very grand ceremony. And the governor came along and opened it and gave a speech, which was great. So one other question I'll ask before we go. Doesn't the Magna Carta override the Constitution? This is a interesting one. you could probably write another PhD on this, I'm guessing, Greg.
Well, you probably could have 100 years ago. Nowadays, the answer is pretty simple. Another one of the changes made by the legislation of 1986 was that all state parliaments, as well as the federal parliament, have the right to override any inherited British legislation. And in fact, not much of the Magna Carta is still in force, even in Britain, because bits of it have been repealed, over the last, how many years is it now? 806 years. Bits of it have been repealed over the last 806 years as they become irrelevant or out of date or superseded by modern legislation. So no, the Magna Carta doesn't have sort of some special unrepealable status. All imperial British legislation that we inherited can now be amended or repealed at any time by the Parliament of Victoria.
Well, there you go. That answers that question. All right. So, look, I'd love to talk longer, and I'm sure there's lots of questions there that we didn't manage to get to. So I apologise to everyone that's tuned in and had a question and we didn't get to it. But maybe Professor Taylor might accept your emails, possibly if you go to Adelaide University's website. I think you can contact him there. And you may be able to ask him some questions. I'm not sure if you mind that or not, Greg. I'm sorry, I just stopped you in there.
I'll see how many I get, but as long as it's a reasonable number, I will respond. If it's not a reasonable number, if too many people email, then we might have to do another one of these.
Yes. Okay. Well, if you get lots of the same question, I'm happy to do another one of these, and we can try and get some answers to some of those questions. But thank you, everyone, for tuning in today and listening to this. I hope it's been informative for you. I've certainly learned a lot myself. And thank you so much, Professor Taylor, for coming along and sharing some of your great knowledge of the Victorian Constitution and government in general and how it works. It's been wonderful for us. Thank you very much.
My pleasure. It's always a pleasure to talk about my personal obsession.
Excellent.
Okay, thanks again. Cheerio.
Thank you, everyone.